Today, our featured speaker is Lucille Ponte, a legal author and retired law professor. She will be covering Piracy on the High Seas, Copyright Basics for Authors. A legal educator for more than 31 years, Lucille taught a wide range of business law and intellectual property courses. She's published textbooks on dispute resolution and contract law and written scholarly articles on copyright, trademark, and legal policy. She previously served as in-house counsel for technology firms and governmental agencies in Massachusetts. She has published a wide range of fiction under her pen name, Bridges DelPonte, including the Marguerite Monty Montez mystery series set in the Portuguese-American community of Greater Boston. Her legal mystery, Deadly Sacrifices, won a Royal Palm Literary Award from the Florida Writers Association. She has also published an underwater fantasy novel, Bridals of Poseidon, a children's book, The Little Dusties, The Roar of the Silver Dragon, with illustrator Michelle Baquet, and numerous short stories and anthologies. She is represented by Kelly Martin at Wendy Sherman Associates, Inc., a literary management firm in New York. Please welcome Bridges DelPonte.
Feel free to ask questions throughout, so it's not going to be just a monologue. Feel free to dialogue with me. I have been a legal educator for more than 31 years. I am a member of the Massachusetts bar, but not the Florida bar. So because this is an educational presentation, I've got to give you a disclaimer, right? If it wouldn't be legal if there wasn't a disclaimer involved. So I'll just have to read this out, and this will make everyone happy. Please note that this discussion and the written information are not intended as legal advice, but are intended for educational purposes only. Legal advice can only come from a qualified licensed attorney who's familiar with all the relevant facts and circumstances of a particular situation and the applicable law. Participants should retain and seek the advice of their own qualified licensed attorney in handling legal matters. So we got that disclaimer out of there, but at the end, I'm going to give you some resources that you can use and hopefully in the future if you have any kind of questions further about copyright. But one thing to keep in mind about copyright is the notion that there's sort of different concepts and people often get them confused. Copyright's the legal part. That's your statutory legal rights to your work. So if you write plays or you write novels or you write songs, that's the legal basis for protecting that work. Plagiarism, I think, is more sort of an ethical issue, whether you're taking, using, or passing off somebody else's ideas, words, or works as your own. Ideas are not subject to copyright. So the fact that there's a million movies out there that are the Cinderella story or the rags to riches or the prodigal son who returns at the family funeral, all that, those are things anyone can use. So ideas can't be copyrighted, but words, the words that you use and the works themselves are protected under copyright, but not just the idea. People always say, oh, that TV show, they stole my idea. Well, you can't copyright, you can't protect ideas. But the actual words you might have used in sort of expressing that idea or the works, right? And then book piracy is a big problem for all of us. I actually, every now and again, to depress myself, I go online and I look to see places where my book has been posted by someone. They had 800 copies of it had been shared, which was really sad. And they wanted to thank him, Bridges DelPonte, because they had no idea I was a female. His work is well known. So it just, people had no idea who I was, but they just uploaded the work. Basically, they probably got it off of Goodreads or something like that, because you can have giveaways there, and then they put it online. So you're always going to have that kind of a problem. And that is a violation of copyright. But let's talk a little bit about copyright and where it came from. One thing to keep in mind about copyright and where it came from is the fact that it's part of the Constitution, because the framers, a lot of them were authors. You know, Ben Franklin and Thomas Jefferson, they wrote books. So they made sure it was right in the Constitution that it was Congress's responsibility to protect for a limited time period the works of authors for their respective writings, and inventors as well. Inventors is patent law. That's an area we won't talk about today. But authors, and authors includes any kind of creator. So if you're creating a movie or if you're creating a song, the word author has been expanded outside of books to basically include any kind of creative content. And it's covered completely by federal law. So there's no state law, folks, on copyright. There's only federal law, and it's protected exclusively by that. All right, so what's covered under copyright? Well, the main thing there is it has to be a creative work. It can't be something that has a function like a dishwasher or a vacuum cleaner or anything like that. That's patent. It has to be a creative work. So for our purposes, books, for example, are protected. Magazine articles, or if you're doing blog posts, someone was talking about they're going to be a blog post, or if you're going to have an interview of you and that's going to appear online, that's all considered to be creative works. So this is sort of a sampling, but for authors, mostly it's going to be your books, it's going to be your stories, it's going to be interviews that might be done of you online, these things, or the videos that we may have created for the reading festival, which I have to say, folks, was really outstanding. I just want to thank Teresa and Lisa and Martha and everyone else who was involved in it, because it really was an incredible effort. And I think it really was a wonderful way to showcase authors. Those videos are protected by copyright. Now, they have to be original. So it has to be what the court calls a modicum of creativity. It's a pretty low standard, because we know, for example, that the Cinderella story has been told a million times in a million different ways. So as long as you can show this is your new take on it, or I'm currently watching, I don't know if any of you have a Netflix, but I'm currently watching The Irregulars, which is based on the Baker Street Irregulars from the Sherlock Holmes story, but it's a totally different story. In this version of it, these irregulars all have superpowers. And Dr. Watson and Sherlock Holmes are villains in the story. So they've taken something and they've added a little bit of creativity to it. So they've taken a well-known story and sort of passed it on. Now realize Sherlock Holmes, or most of Sherlock Holmes, is in the public domain. We'll talk about that a little later. But it has to be something that you've added your own little perspective, your independent creation of. And then it has to be put into a fixed form. So your book has been printed, or it's been put into a file, and there it's on a Kindle. It has to be in a fixed form. That's so you can't say, well, I had an idea for a great mystery and somebody stole it and now I want to sue them. Well, you can't do that because you haven't written your own version of that. So it has to be in a fixed tangible medium. So the videos, for example, on YouTube, that's a fixed tangible medium. So that's all stuff that can be protected by copyright. Now, what kind of rights do you get under copyright? What are the rights of the copyright owner? Well, the rights of the copyright owner are those that are spelled out in the statute, and they're trying to encourage and protect creativity. That's an important part about it, protecting creativity. And so one right that you have as an author is the right to reproduce your work. That basically your right to make copies. So if somebody was to take your book, put their name on it and put it on a piracy site, for example, and they're plagiarizing your work, well, that's violating one of your copyright rights, right? Your right to reproduce your work. Or if somebody was to take a PDF of your book that you had posted or had put on a site, maybe you put it on a distribution site like Amazon, and then they've uploaded it and now they've put it on a site, well, that is one of your rights, right to make a copy of your work. So that's one of the key rights you have as a copyright owner. So that's why you see in the library, when you go in there on the copy machine, it says, hey, if you're making a copy, realize that you could be impacting the rights of the owner. So you can't be violating it. So I can't make a copy of an entire book and then start selling it on the street, for example. Your right to prepare derivative works based on the copyrighted work. That's called your adaptation rights. So say your book gets out there and it's a bestseller, or your story interests people, and they mystery series and the head detective is carried on throughout the entire series. Well, that's your right to make a derivative work. That's your right to make a derivative work. So that's an important thing. That's a right that you have. Not too long ago, J.K. Rowling sued somebody that created an encyclopedia based on the Harry Potter universe. And her view was that she herself wanted to create her own encyclopedia / dictionary, and that this person had violated one of her rights as a copyright holder. So adaptation rights, what if they wanted to take your book and make it into a play? Those are all things covered by derivative works. So that's why sometimes you have people who write what's called fan fiction. Like a lot of people are big fans, say, of the Star Wars universe or Star Trek or Game of Thrones or whatever. Keep in mind that those kinds of works are derivative works because they're based on an existing universe and they're violations of copyright. Now, lots of times the copyright holder will decide not to go after people because they want to keep the buzz going about their series. But they could go after you if they wanted to. So just keep in mind that it's both a marketing tool, but it's also something that a copyright holder could say, nope, you can't do this if you're going to start, say, selling it or providing copies to other people. Your right to sell, rent, lease, or lend copies of your copyrighted work. That's called your public distribution right. That's why if a piracy site takes your work and hasn't paid for it and doesn't have your permission to post it, and then they post it and start selling it to others or lending it out to others, that's a violation of your public distribution rights. So for example, libraries are exempted from this. This is how they get around this idea that they're violating your public distribution rights. But we know now there's a lot of battling between libraries and publishers about ebooks and how ebooks can be lent or whether they can't be lent. So there's a lot more in the digital world that has yet to be resolved, but they certainly have the right now. They're exempt for print copies. And then to perform and display publicly the work. That's called your public performance or display rights. And some folks had asked about this during the festival. I guess there was questions about, am I allowed to read my own work as part of, say, bedtime stories or as part of a noir at the bar? Those kinds of, well, it's going to depend. What rights have you given up to a publisher? So if you've signed a publishing contract, did it only give up your rights, say, to the print version of this? Or did it give up all of your rights and you'd have to get their permission to perform your own work? I know it sounds crazy, but that's the truth of it, folks. So you'd have to look at what does the contract say that you signed with the publisher. A lot of the big publishers take all of your rights. So they want the performance rights because they want to create audiobooks, for example. So they take the performance rights, they take on, then they pay you a royalty based on taking those rights. So keep in mind, if you are self-published and you don't have either a small press or a traditional publisher, then you have all the rights that I've listed here. You have the right to reproduce, to make derivative works, to distribute it, and to perform it. So always take a look at the contracts to see what it is they're scooping up and see, is this what I really want to give them, or do I want to just give them the print rights and, you know, the other stuff I want to keep for myself. So you have to determine that. And of course, audiobooks is a big area now. That's a growth area. I think a lot of it is because people listen to books while they're at the gym or on their commute or whatever it might be. And so you have to look to see, are you permitted to even read your own book? So if it's self-published, you have your own right. You haven't given up any rights to anybody else. It's all yours. But otherwise, it may be something you have to think about. So always look at these contracts to see what it is that they say, because they could impact your ability to read your own work, to distribute your own work, to prepare derivatives of your own work, to reproduce your own work. So it's an important thing to keep in mind. But that's all of the rights that you get. And that's a lot of different rights. So it's a way to supposedly to promote creativity, because you could make money by making copies of it, making derivative work. So a lot of us have mystery series. So you have multiple books that you're creating out of it, or you're selling them at a book festival, or you're performing them. So all those sorts of things. So if the chapter decides to do bedtime stories, those that are reading have to be certain that they actually have the rights to do that, to actually publicly perform it. So you just might want to keep that in mind. What's the length of time for protection? Well, back in the good old days, back in the earlier part of the 1900s, copyright was only protected for 14 years. So a lot of things fell into the public domain. Now, this has been very controversial, but Congress keeps extending and extending and extending how long works are protected. So lots of times works that come out now, they're never going to go into the public domain during our lifetimes. because the time period is so long. So anything created after 1978, if you, the individual, hold the copyright, not a publisher, you hold it, it's the life of the author plus 70 years after your death. So basically you're collecting royalties while you're in the grave. So this is something you can still do when you're dead, which is collect royalties. But that hopefully would go to your heirs. I've always said that I've wanted to be Agatha Christie's granddaughter, because like that person's going to collect money from now until the end of time for all of her fabulous works. So it's the idea of not only protecting the author, but their heirs. So even after your death, this stuff keeps going on. Now, if it's held by a corporation, that typically happens if the publisher owns the rights to the book. Then it's the life of the author plus 95 years. They get a longer period of time. Or 120 years from when you actually initially created the work, whichever is earlier. So whichever is the earlier time period, the 120 years, or if you live a good long life to your 90 and you add on 95, well, that might be longer than the 120 years. So it's a very long period of time, and that means that less things fall into the public domain, which means it's harder for people to create derivative works from things that they might have thought would have fallen into the public domain. And so the idea of copyright is you're supposed to balance the interests of the person who created the work with the public's access to that work. So that means your local high school probably has to pay a royalty for some play because it's probably still protected by copyright. Whereas in the 1900s, things fell into the public domain in 14 years, and that means your local community theater could do a play and not have to worry about royalties. Well, those days are gone. So usually it's very, very hard. That's why a lot of people like to do Shakespeare. He's been long dead, so they don't have to pay anybody a royalty on that. So you can see where there'd be benefits. Or oftentimes you'll see in movies, they'll use classical music because they won't have to pay for the rights to it. So it's a very interesting thing. You know, the time period has extended way beyond. Now, copyright infringement is when somebody violates one of those rights I spelled out before, like your right to make a copy, your right to make a derivative work, your right to distribute it, or your right to publicly perform it. So keep in mind, folks, that as soon as you finish your creation, your novel, it is already protected under copyright. The importance of copyright registration is that you get to sue people if they use your work. So keep in mind that you don't have to register it just by creating the work. Those rights that we talked about under copyright automatically attach to what you've done. So keep that in mind. But if you want to sue somebody who's misused your work, then you've got to register it. We'll talk about registration in a minute. But if somebody makes a copy without your permission, or somebody publicly performs your work, they read your story, they read your novel without your permission, then that's copyright infringement. And they don't have to read the entire work, or they don't have to read it word for word, because the idea is they don't want people. This is where you see some overlap between plagiarism and copyright, which is they're not using every word, but they're taking your same scene and just changing a couple of the words and now saying, oh, it's mine. No, that's still probably going to be copyright infringement. They don't have to do it for commercial or personal gain, so they don't have to do it to make money. That's where a lot of college students get into trouble because they share music and they don't charge their friends, but they share it. Well, that's still a copyright infringement because the fact that they're sharing it for free means that the creator is not getting their money. They're not getting their royalty for the sweat of their labors. So the law is trying to protect them in that arena. And then it's strict liability. That basically means that people will often say, well, I didn't know it was copyrighted. I thought it was okay. Well, keep in mind, just because you think it's okay, the view is that you are responsible to make certain that it is okay. All right, and that becomes the real issue here, because it doesn't have to be, you don't have to show wrongdoing or that someone was trying to harm another party. You basically just have to show that you actually infringe. So intentional and unintentional infringement. And there are potential civil penalties. People can go after you in court and try to get to destroy copies and things like that. Or if it's, you know, deliberate and heinous enough, it could be criminal penalties as well. So it's a big area of law that's out there. All right. Any questions so far on anything, folks? Everybody? Okay. Any questions? All right. Now, how do you register your copyright? Well, there's a great site. It's usco.gov. It's the US Copyright Office.gov. Fantastic site. You can tell it was put together by librarians. It's very thorough and very clear. And you can register both published and non-published works. Maybe you haven't decided that you want to put this out into the public, but you want to protect it with a registration. Well, you can register both published and non-published works with the US Copyright Office. And you need to register either before or within 5 years of when you published it, if you want to be able to sue somebody later. All right. Main steps in the process, it's pretty easy. There's a registration form. You can download it online. That's fantastic. They make it so easy now. And you pay a fee. I think the fee right now is about $35, so it's not super expensive. So if you want to protect your work that way. In the old days, they would say deposit a hard copy of the work, so you'd actually send your book in. But these days, they also accept digital uploads. So that's also a way of doing it, so you don't actually have to give up one of your precious print copies of it. And then they'll issue you a certificate of registration or ownership. And that's useful because if you later on did want to sue somebody in court, you don't have to spend time explaining when you wrote the book and how you did it, and I'm the owner and that I really do own. No, this is your on the table evidence that you are the owner of the work. So the certificate is helpful that way because it saves you a lot of legal fees because you don't have to try to prove that you were the owner of it. And then it also gives you the right to sue and to seek statutory damages. That is, a court can say that not only are you going to get lost profits from someone's violation of your copyright, but they can also give you what's called statutory damages, and that's decided by the court. And that could be anywhere from $200 to $20,000 per work. So say somebody made 100 copies of your work, and the court thinks that they did it deliberately in a criminal, organized group, then they could decide that they're going to add on to any monies that you lost, 20,000 times the 100 copies. So you could so you're talking like, in some cases, it ratchets up to millions, depending on how many copies are made. And then they can also use what they call their equitable powers, where they can force the other party that infringed your copyright, they have to destroy all the copies of it, things like that. And you've heard various stories where it's found out that maybe a famous author has, plagiarized somebody else's work, and the publisher oftentimes has to destroy all the print copies, because that's part of what a court might order for them later on. So just keep in mind the court has a lot of authority and wiggle room depending on the facts to try to protect authors in the future. Now you might say, well, good heavens, with all these rights, how do you get to use any of this work? Well, there's a bunch of limitations. I'm going to give you the main ones. The main limits on all those rights that we have as authors. One is, of course, the public domain. That is that the copyright has expired. So keep in mind that if the copyright has expired on something, then this does indeed give you the opportunity now to take that work and use it. That's why you see a lot of, things, Pride and Prejudice and Vampires, because the thought is, well, the copyright's expired and now I can make a derivative work of it. So that's why you see a lot of classic works being used, because the copyright term has already expired on it. So that's the public domain. A lot of works of the US government, including court cases, for me as a law professor, it was great because you could use court cases because they're considered to be in the public domain. But it can't be things that are already excluded from copyright, like this idea of, oh, I had an idea for a story. No, that's not protected. Or facts. You can't say, well, today the president gave a news conference. I'm the only one that can say that. No, it's a fact. Anybody can talk about that. So there are things. Now, there was a question that came up prior to the presentation about what about clip art or music that you might use in your author marketing materials. So maybe it's, for example, music that we used on some of the videos in bedtime stories or bar or noir at the bar. Or if you're going to put together your own book trailers and you want to put clip art and music in those book trailers. Well, keep in mind that unless that stuff is in the public domain, and there are sites out there, you can find them online, where the work is donated by the creators of the content and you can use it for anything. Or you have sites like Creative Commons where you're allowed to use it, but you have to give some kind of attribution to the person who created it. keep in mind that clip art and music is copyrighted. So that first little bit of clip art that I showed you on the very first slide that I had, I took that from a site that I'm familiar with, that's authentic, that people are donating that content to. So, and they say that you can use it for any purpose. The other thing is look on YouTube. If you're going to post things on YouTube, YouTube gets tired of getting takedown notices from copyright holders. They do have on there a site that I use some of the sounds I created, for example, for bedtime stories, I had some sound effects in there. Some of them I created on my own. I made them in my home and I taped them on my iPhone and then I uploaded them and added them in. Some of the sounds though came from a YouTube site. And if you go onto YouTube, they will say you can just look for free or public domain sounds. YouTube doesn't want to have to deal with all the headaches of people complaining about sounds being used. So I had a police siren that I used in my reading, and that was from YouTube, and YouTube allows you to do it if you're going to be posting the video on YouTube. So sometimes you can find these free sounds. YouTube also has music. There tends to be a little more restrictions about that. So you have to look to see what each of the musical creators has put as a limit on it. But you can get a lot of that stuff. But just keep in mind, don't just take clip art that you think is really cool and put it on your bookmark. Or take, for example, music that you like and stick it in your book trailer. You got to make certain that you have the right to use it. And that's where you look at issues of licensing, right? So in some cases, YouTube has already licensed all these sounds for you. So you're already, that's great, that's terrific. You're acting within the scope of the license, you're taking it and you're posting it on YouTube, all right? That might be fine because you're acting within the licensing of it. I talked earlier about author readings, right? What rights did you give up to your publisher? If they say you can't publicly perform it without their permission in writing, then make sure you get their permission in writing before you start reading it online, or even in a, hate to say, but even in a bookstore reading, that's a public performance. So say we get back to a post-COVID era where people are doing in-person book readings. Well, normally your publisher is going to say, sure, great, terrific, because they want the free marketing. But look to see if there's any limit on your ability to do that, and make sure you get the proper permission so you don't get any blowback later from them that you didn't get their permission and you were supposed to. If you self-publish and you haven't given those rights away, then you certainly are free to do that public reading. So look at what rights you gave away and what rights other people have given to you before you use things. Courts have also allowed for a defense called de minimis use, and this was common in sampling, where people took little samples of music and put it, it was very common, say, in rap music, where they took a sample from another song. And the cases are all over the place on this, so it's really hard to know. But the court does what's called a quantitative analysis. How much of the music did you use? Like how many notes was actually what a court looked at in one case. And they said, you didn't use enough notes, so it's all right. It's to de minimis. De minimis means it's so little, you're bothering the court by even coming in here. So you look at the quantity, and then you look at the qualitative. That is it the heart of a song? Like we know that certain songs that you might hear, the first few notes, boom, gives it right away, gives it to you what the song is, right? So if somebody was to use that, the court might say, well, that's the heart of the song. That's the heart of the song. So you can't say you're just sampling. You're taking sort of the little nugget of gold and using that. So if you're going to say, well, I'm just sampling a little bit of music in my author video and trailer, just realize that the courts are all over the place on what is considered too much or too little. So it's probably safer to find something that's either public domain or that you have the permission of the party to use, or they've given you a Creative Commons license and they say, hey, you can use it. Just make sure at the end of your video you say, thanks to the blah, blah song, thanks to Charlie Music Man who made this. So you've got those kinds of things. So there's de minimis use that we see in the sampling area. The other thing that people often argue, and I as a professor, we often argue this when we're using materials, is what's called the fair use doctrine. Now this, people use it all the time, but they don't know what it means most of the time. So court's going to look at 4 different factors in deciding, okay, is this a fair use? So they're going to see, does this favor the creator of the work, or does it favor the person trying to have access to the work? So they'll look at the purpose and character of the use. If you're using something, say, for educational purposes, or nonprofit, that favors the person who wants to use it because you're not stealing any money away necessarily from the creator. So they're going to look at why, and they're going to look at, are you transforming the work? Are you just making a copy of something, or are you transforming it in some way? And that's a new kind of expression. They'll look at what's the nature of the copyrighted material. So our novels, our mystery novels, those are viewed as creative. They get more protection than things that are informational or factual, like the news report for the given day. Because the news report might be, oh, this is a quote from a government official. Well, you can't say, oh, I'm going to take the copyright. Well, that's a fact, and it's informational, and it's probably going to be something that everyone, like every newspaper is going to want to write about, so you have to let people write about it. But our creative work gets a lot of protection. How much of it did you use in relation to the copyrighted work as a whole? So say you used one line out of a book. Well, you might argue that's not very substantial. It's a 300-page book. I only used one line, so it's not that substantial. I was using it for an educational purpose, and it was an encyclopedia of the human anatomy. So it's something factual. So that's kind of your argument. But what happens if you use one line and it's a haiku poem, which is only 3 lines? Well, that's a pretty substantial use. So the court's going to look at how much did you use in relation to the work as a whole. And then I think what the court oftentimes uses, as if they're really sort of stuck on both sides, it partly favors the person who wants to use it, and it partly favors the author. They'll look at what's the impact of the use on the potential market value of the work. That is, are you stealing bread out of the mouth of the author, basically? So oftentimes the court will say, are you diminishing either the current or the future market for this work by what you did? There's a famous Supreme Court case, believe it or not, that comes out of Florida, of all places. And there was a rap group called 2 Live Crew, and they wanted to do a rap version of the song Pretty Woman. They used a similar chorus, but the other parts of the song were their own words. And some of that, it was more silly than anything, to be honest. It wasn't really obscene or anything. That was more silly. So they were trying to get Roy Orbison to allow them to use a little bit of the Pretty Woman lyrics, and he said no, and they went ahead anyways. And the court later on, looking at fair use, said, well, their use of it was for profit, so that goes against them and in favor of Roy Orbison. The nature of the copyrighted material is creative, so that favors Roy Orbison. Substantiality, well, they used a little bit of it because they wanted to make fun of, they were doing a parody of the song. So they used some of it, but not necessarily a whole bit of it. And the court also said the impact of their use wasn't that much on the market for the song Pretty Woman because it's been out there for 30 years already. And the person who's going to be listening to rap music is unlikely to be the same audience, say, for a rap song. And the court said, if we look at this rap song, it's a parody, it's a satire. So it also transforms the work. So even though that they were using it to make money, the purpose and character of the use, the court said, hey, they made like a totally new crazy kind of song out of it by doing a rap version of it. So fair use is one of these things, it's no set formula. They look at these factors, but I think an important thing that courts will look at are you really transforming the work? And are you in some way hurting the author by what you've done, by using the work? Are you basically taking money out of their pocket? Now, someone asked about the use of song lyrics in author books or in marketing materials. It's not a song you created, somebody else's song. So maybe it's a pop tune that you want to use. This is an area that's got a lot of controversy around it. A lot of publishers do not like song lyrics in a book because they know they're probably going to get sued by the person who wrote the lyrics for the song. And then they're going to have to try to prove fair use. And most of them don't want that headache. So in general, be careful about using song lyrics if you don't have permission from the person who wrote the lyrics. So just keep that in mind. It's a kind of an open issue because there haven't been a lot of cases about it, but I think publishers are gun shy. They don't want to end up in court having a big fight about, oh, you stole my lyrics. You oftentimes can use the title of a song, so whatever, you go on My Sunshine or whatever it might be, but be careful about using the actual stanzas or lyrics within, because oftentimes the title is viewed as a way of identifying the song, but it's not necessarily going to be a copyright violation. A lot of publishers, by the way, don't copyright the title of their books. They only copyright the contents of the book. So there are probably lots of books with the same name that you may have seen, or very similar names. So just keep in mind, folks, that that can be tricky song lyrics. Other copyrighted work, like if you were to use somebody's photo in your book, you have to have their permission to use that photo in the book. Or if you were going to put clip art and things like that, as we talked about before, in your marketing materials, or say you don't want to pay for a cover, so you go and you find, oh, that's a cool photo, I see, I'm going to put that as my book cover, realize you could be in trouble there because that's potentially going to violate copyright. The other thing that might be of interest to us as authors is the notion of the first sale doctrine. That is, you might say, well, then how does a used bookstore get away with reselling my book? Why shouldn't I get a royalty the second time around when they sell it again? Because under the law, there's something called the first sale doctrine. That's the idea that if you have a book and I've read it and I decide I want to sell it to a secondhand bookstore, that is protected. That is not a violation of copyright. So that's called the first sale doctrine. Because the idea is I no longer have that personal property, so I'm selling my personal property to someone else. I can't keep a copy of the book, go and make a photocopy and then sell it, because then I'm violating the distribution right. But if I'm taking the hard copy of the print and selling it, that's why you might see a secondhand record store, right? Where you see LPs in there that people have sold. First sale doctrine allows you to do that. So the law does allow you to sell your personal property, but you can't retain. That's why the digital world now, a lot of digital assets like music, like digital books, ebooks, a lot of them will say you're not allowed to distribute it anymore because it's not a hard copy and there's a worry about you or others making illegal copies, because you can do that so easily now on your computer. So a lot of them will say, oh, you can't do that. And I'm going to go back to our earlier slide because the license I gave you says you can't do it. Now, we don't right now have licenses on print books. I know sometimes there's been an effort to do that recently, but it hasn't panned out in the global economy. But just keep that in mind, that the first sale doctrine does protect used books being sold. And so you and I might have a book that's been sold 3 or 4 times, but we're probably only going to get the royalty once. And the view is that one royalty that we got, that pays us for all of our hard labors. And that others can then take and sell that book to a secondhand bookstore. So just keep, that's another important defense that's out there. Now, what are some other sources? Go to www.copyright.com. It's a fantastic site, folks. It's also a site that you can search with keywords. So if you want to know something is already out there as a book title, say you want to come up with the book title, but you want it to be something somewhat original or quirky or different, go on to that and you can check it out and see, hey, maybe there's a book that's already got that name. So that there is a searchable database, which is really incredible, because in the old days you had to physically go in there and go through reams of files. Cornell University has a wonderful copyright information center, and it has lots of video tutorials about how to register for a copyright, what is a copyright, what's covered. So if you like to watch videos and you're interested in learning more, that's another way of doing it. And then if you are in some kind of, you have an individualized copyright issue that you need an attorney's help for, the Florida Bar does have a find a lawyer thing, which is great. It's online. It's www.floridabar.org, where you can look up lawyers. And you may want to, especially if your issue is all about, say, copyright, look for an attorney who has a certification in intellectual property. That means this is an attorney who has extensive experience and specializes in intellectual property. Intellectual property is copyright, trademark, and patent law, and it could involve trade secrets and other things too, but that's the primary. So that is a good way to get someone, you know, don't go to your local friend who's a real estate attorney and expect them to know everything about copyrights. It's a very unique and individualized field. But I hope that's given you some food for thought, and I'm happy to answer questions that you might have about copyright.
All right, Lou, there is a question in the chat room from Harold. He wants to know if quote unquote Orient Express or quote unquote Heartbreak Hotel would be in the public domain.
That I don't know, but you could go on to the uscopyright.gov and type those names in and see what they say as sort of the copyrighted dates for those, and that will give you some background. Because remember, a lot of these, it's unusual because if you're looking at various works, the extension of copyright may have impacted them. So go on to copyright.gov, put that in there, and you'll see who's the last time someone's copyrighted it, and then you can look at the life of the author plus 70 years, or if it's a corporation like it's Simon & Schuster or it's HarperCollins or whatever, then you're going to have to look at the corporation time period for that.
Okay, he also asked, can he have a character say, quote, I'm reading Murder on the Orient Express without getting permission?
Generally, in general, titles tend not to be protected by copyright. And so courts will often say, if you look, we'll go back for a minute to our discussion of, say, fair use, which is you're not basically taking the story of Murder on the Orient Express and putting it in your book. You're just saying, I'm reading this. So a lot of courts would likely argue that it's probably fair use, or you could also claim de minimis use, that it's just all you're doing is the title. You're not delving into the text of the book. And so I oftentimes will say, for example, I have it's not a mystery, but it's a women's fiction book, and one of the characters is a media professor, and she's always talking about the TV shows that she's watching. That's probably going to be okay as long as I'm not taking dialogue out of those TV shows or things like that. So in general, just using a title, but be careful. You might say, oh, Murder on the Orient Express, the worst book I ever read, then they might try to claim you're disparaging, and that could bring in trademark, not copyright. So just a bunch of other things out there you have to take into consideration.
We also have a couple of comments and questions about the use of song lyrics. Linda said that she used one of Engelbert's song lyrics, but he gave her permission in writing. And then Harold followed up with, can he have a character sing, for instance, since my baby left me, I have a new place to dwell, the first phase of an Elvis song?
Well, see, this is this whole issue about song lyrics. So first of all, in the case of, is it Engelbert Humperdinck who gave the rights?
I have to think so. I don't have the last name, but
that's the only Engelbert I know, but maybe there's somebody else out there. I don't know. But keep in mind, if you have, there's two things you got to keep in mind. Does Engelbert Humperdinck have the rights to his own songs? That's the number one. People often think it's the artist who has the rights. Maybe they do, maybe they don't. He might have sung a song that was somebody else's song that he didn't write. So keep in mind that you have to make sure that the person who agreed to allow you to use this actually has the rights to give to you. There's a famous case involving, if you remember the movie Malcolm X, which was, I'm going to blank on the director's name now, I'm going to kick myself. Very famous director from New York. Oh, why can't I remember? But the actual director of it, somebody tried to claim that they were a co-director of it. And the court said, well, and the person tried to claim that they were involved in the movie in various ways. And the court said, well, number one, you can't be the co-director because the director doesn't own the rights to the movie. The studio does. So that was part of it, which is that you couldn't, you know, the director can't say you're a co-director because the actual owner of the copyright was the movie studio. So you have to make sure it's the person who has the rights to it. Now, this issue of song lyrics, this is where I told you it's very dicey. I'm just going to tell you, it's very dicey. It depends on how much you use. It depends on the context. And again, you might have defenses like if you can say that the song is in the public domain, like it's classical music or something, or it's an opera that might be in the public domain, then maybe you can use the lyrics if it's in the public domain. Or if you used a small part of it, you might argue, well, it's only a de minimis use, or it's a fair use. That is, if I look at these 4 factors, I'm not really hurting it. But keep in mind that, I don't know who's out there looking for lyricists, but it seems like they're a litigious group, let's just put it that way. And so you have to be very cautious about using song lyrics, because a lot of them will say, you have to get my permission. And as I told you, most traditional publishers will not publish a book that has other song lyrics in it because of that fear. It's not that you're going to be right or wrong, folks. It's, do you want the lawsuit? Do you have tens of thousands of dollars in your back pocket that you can spend to fend off a copyright claim? I don't know about you, but I don't have that kind of spare change in the couch cushions. So it may be something that you want to think about. People will often say to me, well, can I get sued? Folks, you can always get sued. Can you win? Maybe. But that's the big question. Can I win? And do you want to spend all that money to be a winner? You know, so the question becomes, you know, what are you going to do? So you have to be cautious these days. And I think part of it is because we are so much online, it is very easy now for publishers to find things and for lyricists to find things online, which might have been harder to find if it was just done in print copy. So most people are doing ebooks or have some version of it in a PDF. These things are a lot easier to search. Or if you've ever tried to, even as a professor, I used to upload things to YouTube for the students to watch later, a lecture that if they were sick, or when we were, during COVID, we did it quite a bit. And a couple of times things bounced back to me from YouTube saying, well, you're using blah, blah, blah. So I would have to explain to them that this was for a class and I'm only using this. And I had to go through all the fair use factors, and then they would back off. So just keep in mind that a lot of this now is done by technology. There's not a person on YouTube reviewing this. There's a software program called, what's called a web crawler, folks. A lot of these different publishers have what are called web crawlers. They're software programs that crawl throughout the web looking for the works of their authors. So it's all become technology now. It's not often done by a human. And then if you push back, then a human might look at it at YouTube and say, okay, it's a professor, it's a class, blah, blah, blah. I'll make it's okay. So yeah, that's the tough part now. I think people used to, I've even done some work on digital sampling in rap songs, and they used to say, oh, we keep doing it until we get away with it. Well, now it's a lot harder to get away with. Because in the old days, it was, you know, done on vinyl. It was a lot harder to find that stuff. So just keep in mind, there's a lot more prying eyes out there than there used to be, for better or for worse.
Well, Lou, in your experience, have you ever like seen a really remarkable case of author copyright like errors? I mean, you did mention like the encyclopedia with J.K. Rowling.
Yeah, and she actually testified against the guy in court, which was not great for him. She said something, I don't have a great British accent, but I'll do my best. She said something like, he took the plum from my pudding. So she basically told the jury that he had taken the heart of her work and taken it away. So it's going to depend. I mean, it depends. It's like some authors are more laissez-faire about it. Now realize not all authors have the same tolerance one way or the other. For example, I talked about the fan fiction for Star Wars. There's a ton of fan fiction out there where people aren't charging for their work, but they're writing their own stories of, you know, Princess Leia and Han Solo and Luke Skywalker and those kinds of things. Well, the owner of the copyright doesn't have to go after them. That's a choice. So they might decide, and they have decided, if you're just sharing this online, and it's keeping the buzz going about in between the Star Wars movies, about the Star Wars universe, then oftentimes they can decide that they're not going to take action. It doesn't mean they won't change their mind tomorrow and say, oh no, we're going to take action now. But just keep in mind that it's up to the copyright holder to decide. Now, some copyright holders might say, hey, great, get it out there because it's going to be a great marketing tool for all my other works that I have out there. So it really depends a lot on the copyright holder, the publisher or the author, and how much of this they want to allow to go forward.
You know, on that topic, you could maybe clue me into something. I've always heard with like Star Wars and Star Trek that there's an official canon, right? Like that's the canon of the universe. And then they have these satellite stories that's fan fiction or whatever, any kind of media nowadays. And every once in a while, the official canon will take a character from fan fiction and work it into the canon world. Is that the copyright owner making that decision?
Teresa, that's such a great question. I always tell people that if your book is famous enough and best-selling enough for there to be fan fiction, you don't have to go after them. And remember, one of the things we talked about, I'll just go back for a minute because it's a great question, Teresa, is this idea that the right to prepare derivative works. If I created, say, the Star Wars universe, and canon means the authorized storytelling, not all the fan fiction that has grown up around it, right? But it's the authorized versions of it that are protected by the copyright because these characters are still well within the time period. They're not in the public, like Princess Leia's not in the public domain, Luke Skywalker, none of these are in the public domain. First of all, Lucas is still alive, so I mean, that's one thing, because remember, it's the life of the author plus 70 years. So just keep in mind that a lot of this stuff is still covered by copyright. So if I was to write a fan fiction version of it, and they think, wow, that's a great storyline, guess what? They have the right to use it. Why? Because they have, as the initial creator, the right to prepare derivative works. Now we might say, oh, that's not fair, that's kind of unethical, that's plagiarism. You can argue that, but it doesn't violate copyright. So if they see a great, I always say, if I was them, I'd let all these storylines go out there and pick and choose the ones they think are winners. Now, it doesn't mean they can then take the actual words used by the person who wrote the fan fiction. That might be a question. But the nugget of the story, there's a famous case, I'll give you one that involved, if any of you remember the HBO series 6 Feet Under, it was about a family that owned a funeral home and a son, the prodigal son story, who comes back and helps to run it. Well, there was an individual who was, this is so hilarious, but who was a writer who wrote a script that was focused around someone coming back to run their family funeral parlor. And they happened to share a physical therapist, I think it was, or a massage therapist with somebody who was at HBO. So the person said, who wrote the original, this was about, it was set in a funeral home and about a family and someone coming back to run it and all that sort of stuff. They gave a script to the physical therapist who then passed it on to the executive at HBO. And then when 6 Feet Under came out, they claimed, hey, that's my script. You stole my script. So the court had to do a review of that script compared to the series 6 Feet Under. And the court determined that 6 Feet Under was a different story, that the original script was meant to be a comedy and it was kind of silly and sort of, whereas 6 Feet Under was a more serious drama that took on lots of serious themes, and that this idea of a prodigal son coming back to run the family business is an idea that anybody can use. So it's very interesting that if you've got this fan fiction and you think the storyline is interesting, you could say it's an idea that anybody can use. And since I own the right, say, to Star Wars or Star Trek, I can then adapt it, adapt that idea. Because remember, ideas are not protected. But you couldn't necessarily take the person's whole cloth fan fiction story and copy it that way. But you certainly are probably going to see maybe ideas gleaned from that you could use. if that helps, Teresa.
That does help. And we have a note in the comments box, the chat box from Sarah. She said that Marion Zimmer Bradley used to publish fan fiction of her fantasy world until a fanfic author threatened to sue her over stolen ideas and she had to scrap the novel. So that fits into what you just said. It's like they can take a look at it and just back out, like back away.
Right, and yes, that's definitely true. And then the idea, it's not that the court's protecting the idea. Copyright doesn't protect ideas, but your expression of those ideas. So how you, the dialogue, the interaction, the emotions, the words, that's what's really being protected. Because as we know, there are many, what do they say? There's 7 stories and we keep retelling them in all different ways. So, I mean, that's sort of this, like, this notion that ideas don't get protected. But, you know, sometimes fan fiction works out. For example, my understanding is that I think it was 50 Shades of Grey was initially fan fiction based on Twilight. And then they completely changed it up to be this much more erotic situation where there's a love triangle and S&M and all that stuff. So sometimes fan fiction becomes so independent from the initial work that it was writing about. Like her earlier drafts were supposedly about the Twilight Saga. And then she changed it all. They weren't vampires anymore. They weren't Bella and all these characters. But now there was this woman and this rich guy, and, you know, the rest is sort of history, as they say. So sometimes fan fiction is not so derivative that it can be viewed as a violation of copyright if you really do change it up.
That's awesome. I believe we've covered all of the questions in the chat room. Does anybody have anything else for Lou while we've got a few minutes?
And again, folks, do look at those resources. I think that the U.S. Copyright Office does a wonderful job, and Cornell gives you those videos. And then you can always reach out if you really have a serious problem to the Florida bar to get somebody to defend you.
All right, well, thank you, Lou. I'm seeing a lot of comments in the chat room. Everyone is just delighted with this excellent informative presentation. This is going to be so helpful, especially once we get it up on YouTube. We'll push it out to everybody because this is such a pertinent topic. And we do appreciate all of the information that you shared with us today. And
thank you for inviting me. I appreciate being able to share the information. I think authors need to know more about protecting themselves.
Absolutely, and thank you again for your work at the festival. That was great fun. And we look forward to seeing more of you in some of our events going forward. All right?
Thank you. I look forward to it as well.
Yep. Oh, it's just full of thank yous in the chat room. All right, everybody. That will wrap us up for this month's meeting. Thank you all for attending. And we'll hope to see you next month when we have another topic. And in the meantime, everybody, just stay safe, stay healthy, and we'll see you next month.